Welcome back to another episode of Kay Shares Knowledge. So in today's video, we are going to be discussing how do the courts vary the equal share rule. Now, of course, in order for us to ascertain how the courts do this, we must turn to Section 7, subsection 1 of the Property Rights of Spouses Act. Now, of course, before we get into anything, here are two key disclaimers that we have to keep in mind once we're learning all of these things. Number one, nothing in the law is absolute. Everything depends on the set of circumstances that might exist. Number two, the information being shared in this video is only being shared specifically for educational and informational purposes only. So without further ado, let's go ahead and jump right in. Now, let's go ahead and kind of go back over some of the founding principles when it comes down to the equal share rule. Number one, the equal share rule will specifically apply to common law spouses and married persons. Now, what is a common law spouse? Remember, a common law spouse is where a single man and a single woman are cohabitating for a period of no less than 5 years, and they live as man and wife, and they have a shared family life. All right, so that is our founding principle. Flowing from that, you have the definition of the family home. So you have a common law spouse, you have a common law union, and they live in something called the family home. Now, what is the family home? The family home is the principal place of residence of the spouses, and the family home must be owned by either of the parties, either the man or the woman, or it can be owned by them both. So you have a common law union, they live in the family home. Great. Now, once you have established that there is in fact a family home, the next step is to appreciate the concept of the equal share rule. Now, what is the equal share rule and when does it apply? So remember, we established that the equal share rule is a presumption in law that upon the termination of cohabitation of the parties, or where it is that the parties are no longer able to reconcile, or there is a decree of dissolution, then the automatic presumption is that both parties are entitled to a 50% interest in the family home. So remember the flow of the conversation. Common law union, they have a family home, they separate, both parties get 50% interest. All right, those are founding principles. Now remember, the equal share rule is an automatic presumption that takes place in law. What do I mean by automatic? It means without any of the parties doing anything, this principle will automatically apply, meaning it applies as of right. So the parties don't have to do anything specific for it to apply, it just applies out of right. All right? Okay. Now, of course, with all presumptions, we have to always bear in mind that the presumption can be rebutted. Yes. In fact, Section 7, subsection 1 of the Property Rights of Spouses Act gives the spouses an out. It gives them a gateway that they can meet in order to get the court to say, this presumption of an equal share rule can be rebutted. Now, what does all of that mean? Section 7, subsection 1 essentially allows the court to say, all right then, yes, the automatic presumption is a 50-50 interest, but if certain circumstances exist, then this presumption can be rebutted, meaning that instead of giving both parties a 50-50 interest, then the courts can vary the equal share rule and instead give the parties what they deem to be fair. Now let's go ahead and take a look at Section 7, subsection 1 of the Property Rights of Spouses Act. It reads as follows. Where in the circumstances of any particular case, the court is of the opinion that it would be unreasonable or unjust for each spouse to be entitled to one half of the family home, the court may, upon application by an interested party, make such order as it thinks reasonable, taking into consideration such factors as the court thinks relevant. Including the following, not limited to. Number 1, part A, that the family home was inherited by one spouse. Part B, that the family home was already owned by one spouse at the time of the marriage or the beginning of cohabitation. Part C, that the marriage is of short duration. And then it continues to subsection 2, which I will not read at this time because it's not relevant to what we're speaking about. Now, what is section 7, subsection 1 saying to us? Let us try to digest it. So first of all, remember that the equal share rule is an automatic presumption. So what section 7 does, on the other hand, is it says, okay, fine, the equal share rule is an automatic presumption. But if any of these factors exist in the particular circumstance, then the court can say, all right, then we're going to vary the equal share rule and give the parties a different allocation. So we're going to take this section bit by bit. All right, so let's start from the top again. Remember that the section says that if the courts think that it is unreasonable or unjust for the both parties to get 50-50, this is the threshold that any applicant must meet in order to get the court to vary the equal share rule. Remember, when you're coming to the court, to prove based on the evidence that you have that, Your Honor, it's not just, it is not fair for the other spouse to get a 50-50 interest. Why? Because the particular circumstances show that it is not fair. So this is the threshold that must be met. It must be unjust. It must be unfair for the other party to get a 50-50 interest. And the reason is because, remember, a marriage or a common law union is a partnership of equals. Remember, the presumption in law is that once two parties come together, both of them need to be financing the union, they need to be partaking in their assets, pooling them together in order to create the family life that they want. So it's an equal partnership. But what the legislators are saying here, what Parliament is saying is that, yes, a marriage is supposed to be, or a common law union is supposed to be a partnership of equals. But if an applicant can show that the partnership wasn't equal to begin with, because these circumstances existed, then the courts are empowered to vary the equal share rule. So remember, you have to be able to prove with evidence that these circumstances apply to you. So essentially, if you fall in any one of these categories, then you can potentially be successful in your application to get the court to vary the equal share rule. Now, the next thing we have to appreciate is that this section specifies that an individual needs to apply to the court to vary the equal share rule. This means that this individual needs to make a formal application to the court to say, hey, court, no, the 50-50 rule should not apply because I fall into one of these categories. So let us take a look at the first prong, which is part A. It says that the family home was inherited by one spouse. Now, what does that mean? Let us say, for example, that you have Tom and you have Tisha. Tom owns the property, the title is in his name. But Tom only acquired this property because his grandaunt, Aunt Rose, left it to him by her will. Yes, so Aunt Rose wrote her will back in 1990, and she said, I go ahead and give this property located at 2 Bridge Lane to my nephew, Tom. So that means that Tom acquired the property via a will. He inherited it. He didn't get up and buy it. He didn't get up and invest in it just like that and just acquired it. No, in fact, he had inherited it. Now, what this section is saying is that if Tom can show proof that, yes, I inherited this property from my grandaunt Rose, then the courts may say, okay, so this has opened the gateway for the courts to say, all right, we're going to vary the equal share rule. So maybe in that case, Tom and Tisha, before the court, would not be getting a 50-50 interest. Maybe in that case, upon an analysis of all of the evidence that is presented, the courts might say, maybe it wouldn't be fair to give Tisha 50% interest. Instead, we're going to go ahead and give her 20 and Tom will get 80. So that is what I mean when I say that the courts have the power to vary the equal share rule. But the burden is on Tom to prove that he inherited the property. He must prove. Remember the principle in law. He who asserts must prove. Now the second one is part B, and it says that the family home was already, keyword, already owned by one spouse at the time of the marriage or at the beginning of cohabitation. Now what applies to us in this instance is cohabitation, because we're specifically talking about common law unions, right? Common law unions. Now, what is the legislator trying to tell us via this section? So let us say, for example, you have Tom. Tom decided to buy a property in 2005 located at 2 Roswell Terrace. He buys this beautiful 3-bedroom home, a beautiful garden, a beautiful bathroom, all of the works. Porcelain tiles, lovely kitchen. It's perfect. So Tom buys this property in 2005. Pay attention to the time period. He buys it in 2005. Then in 2010, he decides to get with Tisha. So Tisha moves into the property and the two of them start living together as man and wife. They're not married. They live together as man and wife. Then, because of some, problems and some issues, the parties decide to separate in 2016. So remember, they were living together from 2010 all the way to 2016. Tisha decides that she's going to move out of the property. And Tisha decides to make an application to the court that, hello, I have a right to a 50% interest in the family home and I deserve my share. Now, what are the courts going to do when they take a look at all of these facts? What is the court going to be taking a look at? Number one, the courts will have to satisfy themselves that the two parties are in fact in a common law union. That's the first thing. So the courts will say, all right, they have been living together as man and wife for a period of at least 5 years. In this case, they were living together for 6 years. So yes, they are in fact in a common law union. That's number one. Number two, the courts are going to look to the definition of the family home. That's the next threshold. So they will say, 2 Roswell Terrace is owned by who? Tom. Remember, the criterion for the family home is that it must be owned by either or both parties. In this case, it's owned by Tom. So therefore, it can be qualified as the family home. The third thing the courts are going to look at is, okay, automatically the equal share rule will apply. That is the presumption that will automatically apply. Why? Because the two parties are in a common law union and they live in a family home, because the family home is their principal place of residence. That is where they've been residing together. So therefore, it is the family home. However, the burden will be on Tom. Tom has a lot of responsibility in this situation. The burden will be on Tom to prove to the court and to say, hold on, court, hold on. It would be unjust and unreasonable for Tisha to get a 50% interest in this property. Why? Because at the beginning of us moving in together in 2010, Tom, already owned the property. Tom already owned the premises at the time that they had even begun living together. So therefore, it would be unfair if Tisha got a 50% interest. So the burden is on Tom to rebut the presumption that the equal share rule will apply. Now, if Tom is able to show proof that yes, it would be unfair, then this will open the gateway for the courts to consider a multiplicity of factors. So why is this important? It is important because, remember, when we're looking at a marriage or a common law union, it is an equal partnership between both parties. What Section 7, however, does is it says, yes, marriage or a common law union should be an equal partnership, but there are certain instances where it wouldn't be fair for the other party to get a 50% interest. Why? Because they did not put in to the family home as much as the other person did. This is important. In the case of Tom could show to the court that he was already well established prior to meeting Tisha. He already had his property. He didn't need her contributions in order to get it. So Tisha didn't contribute to the deposit of the property, the down payment. Tisha didn't pay any mortgage payments from 2005 to 2010. Tom himself was the one who was maintaining, upkeeping the property from 2005 to 2010 when he met her. So he already had his assets. So therefore, he didn't need her input to be able to establish himself. This is important. Why? Because remember, a marriage or a common law union is a partnership of equals. If one party is already a bit more significantly well established, then the other party would not be able to claim as much of a right to the premises as before. It would not be fair and it would not be just, because you'd be showing to the court, I already had what was mine when I met her. What I had belonged to me. Therefore, she did not put in as much as I did. Therefore, it would not be fair for her to get as much as I should. So this part is very important for us to understand. Remember that whenever you're making an application under Section 7, subsection 1, this is a bar that you must meet. This is a threshold that you must meet. That it would be unfair, unjust, or unreasonable for the other side to get a 50% interest because a certain set of circumstances exist. Now to the last one, part C. This one doesn't necessarily apply to a common law union because it is being specific to a marriage. Now my next couple of videos will be focused on the topic of marriage and divorce, and it will also speak to the idea of a marriage being of a short duration. In summary, based on the authority of Gardner and Gardner, when it comes on to looking at a short duration of a marriage, the courts typically look at a marriage of around 4 years. In their opinion, it's likely that if you're married for only 4 years, then that will be considered as something too short for you to justify getting a 50% interest. But I will leave that topic for another day, as that entails a more extensive discussion when we look at the topic of marriage. Now, in summary, that pretty much explains how the courts vary the equal share rule and whether or not they have the power to do so. So once again, the automatic presumption is that both parties will be entitled to a 50% interest, but that presumption can be rebutted provided that a party makes an application to the court that they fall into a certain set of circumstances, and therefore it would be unjust or unreasonable for the other spouse to get a 50% interest. So I hope you all found this video to be very educational as well as informative. Please ensure that you like, share, and subscribe, and stay tuned for my next video, which will be continuing on the topic of marriage and common law unions. Thank you for watching. Take care.